Hi, welcome back to the podcast, HOA Hell. I'm your host, Michael Kushner, and with me today is a new face that you haven't seen before. This is Senior Associate at MBK Chapman, Jess Rodriguez. And Jess Rodriguez spent about 20 years at the Orange County District Attorney's Office as a Deputy District Attorney. Is that correct?
That is.
Okay, and so you joined our firm a few months ago, decided to change careers, and have joined the civil side. But today, because of the nature of what we're going to be talking about, I wanted Jess's expertise because he has a unique expertise and knowledge base that we at this firm that only have done civil law just don't have. And so welcome to the podcast, and thank you for joining me today.
Yeah, thanks for having me, Mike.
No, I appreciate it. Thank you very much. So today, we are going to be, the title of this show today is going to be California HOA board members go to jail in California. What's actually a crime and what isn't? And the reason we're doing this show is because this is actually topical. There's been some, and we've talked about this in a couple of previous episodes, there have been some high-profile cases in California involving crimes like embezzlement, for example. We talked about in our embezzlement episode, where directors or management companies have actually been arrested and are facing criminal indictment or facing criminal charges. And so it's actually trending right now, and I thought it would be interesting because I haven't seen anybody else really focus on that aspect, especially because most of the crimes that we are going to talk about today that kind of that have to do with HOA life also have civil components to them. And in fact, I would say a lot, not things like murder and stuff like that, even though there you have wrongful death and you have civil components even to murder, I guess. But a lot of this stuff, even like embezzlement, for example, the embezzlement might be criminal, but there's also civil claim for embezzlement, and then receipt of stolen property as a civil component, as does a breach of fiduciary duty, breach of contract, negligence, all those things. So there are civil and criminal components to some of these things. So Jess is gonna offer his expertise and knowledge to us today. So today, that's what we're gonna talk about. We're going to talk about where and when behavior by directors or the board members become criminal, and we'll separate what's criminal, what's not. We'll kind of the myths surrounding things that sound criminal but really aren't, and things that you would think should be criminal and aren't, even if they don't sound criminal. And then we'll walk through some real cases, real crimes that happen inside HOAs in California, and then where that line is and really what the differences are between just breaking the rules and crossing that criminal line, okay? So let's start with when board misconduct becomes criminal, okay? I think I'm fair to say, and I think you'll agree to this, Jess, that most of the HOA wrongdoing that we handle in our firm is civil. Is that right?
Absolutely, yep.
Okay. And things like breaching fiduciary duty, which is a very serious offense, or violating the Davis-Sterling Act in all sorts of ways, or enforcing rules unfairly, selective enforcement. Those are all civil, okay? We'll talk more about that later. But there are certain kinds of things that happen in HOA life that can be charged criminally. And the ones that most often are criminal in nature or that we see in our civil capacities, I'll start with the first one. I'll let him talk about a few. The first one is the one I mentioned a couple of minutes ago. It's the most obvious, in my opinion, as a person that doesn't have any criminal law background, and that's embezzlement. Could you tell me what embezzlement is criminally? What do you guys mean when DAs talk about embezzlement?
Sure. In the criminal sense, it typically means there are funds, money that's supposed to go for a certain purpose, and someone takes it and takes off with it, uses it for their own purpose, uses it in a way that it's not supposed to be used. We see it in the criminal sense outside of HOAs often, maybe a school board treasurer or someone who gets the responsibility of taking over a bunch of people's money and is supposed to do something with it, and they take it for their own use.
Okay, so in this case, let's say there's a special assessment out there of $5,000 per household, and you've got let's say you've got $500,000 coming in as a result of that, and one or more members of the board take $50,000 of that and beautify spend it on landscaping for their own homes. Okay?
Right.
That would be embezzlement, wouldn't it?
Yeah.
Now, it would also be a breach of fiduciary duty. So we'd certainly have a lawsuit there. It would be, breach of contract. It would be breach of the CC&Rs for sure. And receipt of stolen property under 496 of the Penal Code has a civil component. We use it all the time when we file lawsuits. It's a great way to get triple your damages. So that civil component gives you treble damages, but it is also criminal. And that would be what you were just talking about, criminal embezzlement, right?
Yeah, absolutely. Okay. It'd be that crossover of both a criminal and a civil offense.
Right. And then, and so the next one that happens in the context of HOA life that could be prosecutable is something called theft by false pretenses. What's that?
Again, if to use an easy example, if we were outside the HOA world, tricking someone into giving you their money or their property. You can see how that could apply in an HOA setting.
Give me an example in an HOA setting. Just make up a fact.
Sure. Somebody indicates that, we're raising dues because we need to build a new sprinkler system.
Right.
And so you agree to do it. Maybe you vote on it because you think that's where the money's going, and it turns out that's not what the money's for.
So let's say you used to pay $200 a month and they want to raise it to $210. You don't need a board vote for that. Or in your scenario, they're raising it enough to where it triggers the requirement to get a board or a member vote. So let's say you do that. But really their goal is we're gonna keep spending the $200 a month doing what we always did, but that extra stuff we bring in, we're gonna give to ourselves as a bonus.
Yeah, the fact
that's embezzlement too.
Correct. And when we talk about the trick part of it, the fact that you agreed to pay more money doesn't take them off the hook and doesn't make it not a theft anymore, because the reason you're agreeing to give them more money is for a specific purpose.
The sprinklers.
Yeah.
So what I'm learning right now, and this is probably why when we read about prosecutors prosecuting crimes, there's always a bunch of different claims or a bunch of different, what do you guys call them?
Charges.
Charges, right. So you have a bunch of different charges, and some of them often seem really similar, and they blur lines. And so what you might be prosecuting, you might prosecute those board members for, theft under false pretenses and also embezzlement, because it met both of those descriptions, right?
Sure. You can have one action with, a handful of different crimes.
Right. So we see that. So in our scenario with the sprinkler system, we would have both. And in that first example, we would probably not have both because there was never a promise. It was just they took the money.
Right.
Okay. Unless the intent at the beginning, and we'll talk about intent in a minute, unless the intent at the beginning when they did the special assessment of the $5,000, unless the intent was to really take that money for something else and not just take some of it to use for themselves because they had extra at the end. It was like, we're going to say it's for that. Then you would have both.
You'd have to prove it, but yeah.
Okay.
Yeah.
Well, no, I wouldn't have to prove it. The DA would have to prove it. All right. Then we have something called theft from an elder. Now, before I ask him what that is, in civil claims, when we bring a cause of action, and we've done this, for elder abuse, there's a series of statutes under the Welfare and Institutions Code in California, which protects senior citizens from being taken advantage of, either medically or financially, by other people that aren't senior citizens. And among the potential compensatory damages available are, first of all, the statute has an attorney's fees provision. So if you sue successfully under a Welfare and Institutions Code elder abuse claim and you win, you are entitled to your attorney's fees. But there's also the potential for triple damages. So whatever your actual damages are, the court can multiply that by 3 and award the prevailing plaintiff, the senior citizen, triple damages. Now, our law firm, MBK Chapman, had a case in 2024 in Long Beach. It was in the newspapers. We got a multi-million-dollar verdict against a real estate developer who took advantage of one of our clients who was a senior citizen, basically stole her home that she had owned for decades. And we ended up getting, because we got triple damages, we got several $1 million. That was paid in full, by the way. So that has teeth. But what would absolutely constitute elder abuse under civil law also has a criminal component to it. And I didn't know this at all until you told me about this when we first started, when you brought this topic up and we were talking about it. Tell me what theft from an elder is, and kind of just briefly, if you happen to remember what the elements are, because I know that wasn't your area of expertise when you were prosecuting. You prosecuted certain crimes. We won't get into that. But if you happen to remember, tell me about theft for elder, or
Sure.
theft of an elder.
So criminal has a lot of the same concepts where the law wants to protect elder adults as well as dependent adults. But in criminal, you don't say, all right, well, we're going to triple your damages, because you're not fighting over money, you're fighting over liberty, right?
Prison time.
Right. So The equivalent in the criminal sense is to increase the penalty when a crime is committed against an elder.
Now, there's a word for that. I've heard it before. Like when people use a gun at a crime, what's that called?
It's a sentencing enhancement.
Enhancements. Okay. So theft of an elder or theft from an elder is similar conduct to what I was describing, though, right?
Yeah. The theft is the same, but what changes is you have the additional component of who the victim is. And if you establish that the victim was an elder adult and that the defendant knew the person was an elder adult and then committed this crime anyway, then there can be an enhanced
Is that
penalty.
necessary that you know that you're dealing with an elder?
Yes.
So if you're dealing with somebody on the internet and you have no reason to believe that they're not 35 or 40, even it might be 95-year-old, you're not going to meet the elements for criminal, right?
Yeah, I can't think of an example where you're still on the hook if you didn't know the person was an elder.
But in most situations in HOA, you actually know who your people are,
right.
So you can see them. That person looks 80 years old.
Right.
Okay. Right. Okay, and that brings us into, before I go through that last one, which I already mentioned is a civil component, I said something a few minutes ago, and I want to follow up on it, and that is intent. In civil, intent is, in many cases, completely irrelevant. Now, sometimes it's relevant, but at least in the claims that we were talking about today, and breach of fiduciary duty, breach of contract, intent's irrelevant. Is intent relevant in criminal?
Very often. And when we talk about theft cases, the answer is almost always yes. There are general intent crimes and specific intent crimes, and we don't have to do a whole breakdown.
Let's not
here.
do the law school thing of that. Sure. I still remember that. 30 years in, I still remember that.
But when we talk about theft, we're talking about crimes where someone has to have the specific intent to take someone's money, to take their property.
Okay.
It can't just be you accidentally end up with it. Unless we're talking about receiving stolen property. But even that has an intent, because that you may not have stolen the property, you may not have intended to end up with it, but at some point you realize you have the property.
And didn't give it back.
You know you still have the knowledge that it's stolen, and then you have the intent not to give it back.
Right. Yeah. Now, if you were to receive it, find out it was stolen and give it back, no crime.
No crime.
Okay, gotcha. All right, so that last one is what you just said, receiving stolen property. So Penal Code 496 is in the penal code. It is a criminal code, right? That's where the crimes are listed, right?
Yep.
Okay. Some penal code sections, a few of them, Penal Code 496 being one of them, if you kind of read down, I think it's section C, if I'm remembering it correctly, is, oh, by the way, although this is a crime, you can sue for this in civil court. And it gives treble damages, which, again, you already mentioned a minute ago, isn't even a criminal concept.
Right.
Because there are no damages in criminal. It's, are you going to jail or not? Are you losing your freedom or not? Civil is where we talk about money, compensatory, right? Unless you're talking about restitution, which we'll get to later. And so there is that civil component, and that is in the embezzlement case, in the theft of an elder, in basically the criminal cases we've talked about today. We could probably include a receipt of stolen property component for all of those. Again, when we sue, we don't just sue for breach of contract or fiduciary duty. We have multiple causes of action because it fits different elements. So same thing in criminal. You charge them with a bunch of stuff. We sue you for a bunch of stuff. Same thing. Okay? So each of those, as he said, today at least, requires a specific intent to commit that crime. That isn't necessarily true in civil. And there's a much lower standard of proof in civil as well. Remember, in civil court, most of the time, the standard is relatively low in that, is it more likely than not? So if you have a pair of balanced scales, if you're a little higher, slightly more likely than not, then you meet your civil element. In criminal, it's beyond reasonable doubt, which is a much higher standard. Okay, and it should be, again, because we're talking about money civilly. Here we're talking about the state taking somebody away and locking them up. Okay? All right. Now let's talk about some buzzwords. Okay? There are certain actions or activities that bad board members, that fraudulent, yucky, HOA hell board members will do that sound very criminal. And we throw these, and I say we, I mean lay people in their regular lives, colloquially speaking, throw these words around, and they sound very criminal in nature. They sound like they're crimes, but they aren't. So I want to be very clear, because we're going to talk about, we just did a minute ago, we talked about real crimes. Now I want to talk about those fake crimes. They sound criminal, but they aren't. That's important to understand. Later on, when I make this clear, you'll understand when you should get the police involved or when you should get the DA involved and when you shouldn't. So, for example, and some of these words we'll talk about them in a minute, extortion. That sounds very criminal, okay? But it's often not, depending. And some of these, even if they reach into criminal, can also be civil as well. But money laundering or misappropriation of funds, when we use those words colloquially, they're often not criminal. They don't meet the intent, the specific intent requirement, and all that stuff. When those words are used by DAs, they could very well be criminal because they're using them very differently than the way we use them in regular life. So that's what we're going to talk about. Let's talk about extortion. Okay, extortion is what? Obtaining property, or an official act of something like that, right? Or threatening an official of some sort that you're going to do something to get them in trouble. They don't pay you, right?
Yeah, extortion. It doesn't even need to be involving an official. But look, I know I've received, your cable bill gets jacked up and you look at it and it's gone up 20% and you say, oh my goodness,
That's
what
extortion.
Is this? This is extortion. What are they doing to me? Like, we use those words, but in criminal sense, extortion means something very specific. And what's missing is that there has to be a threat of harm to you, to a loved one,
right. And we physical harm too, right?
Correct. Yeah, and we typically don't see that.
Right.
So it's not. We use the term extortion, but what we're describing is actually not extortion.
Right. And a perfect example is something that we see, and Jess does consultations with clients at the firm. We see this come up a lot. And for example, they're about to do a special. We've talked in many episodes, especially after the balcony law, we've talked about massive special assessments of more than $30,000 per household, $30, $40, $50, even $60,000 that we're seeing in epidemic proportions. And we often, frequently hear people say, I got to write this check now. That is extortion. I'm being completely screwed. My HOA is insane. They're extorting everybody. They're using that word wrong. What they mean to say is it's ridiculous, it's absurd. They breached their fiduciary duty for years. They failed to maintain, and that's where we at and all that. But it's not extortion. So when the word extortion gets used most of the time in the context of an HOA, it's not being used right, and it probably isn't criminal. Now, if you're a board member, correct me if I'm wrong here, if a board member were to come to somebody and say, look, we dinged you, you got a hearing coming up for violating this or that rule. You give me $100 and I'll make sure you win that hearing. Okay? Would that be extortion?
I don't even know if that would be extortion without the threat. It's certainly a bribe, and we might be able to find.
If you don't give me $100, not only am I going to make sure you lose, but I'm going to beat your kid up.
There we go.
Okay.
Now we're getting to it.
Okay. That's also, by the way, I bet you that would be IIED, intentional infliction of emotional distress.
Yeah.
Just did an episode on that, and that might rise to that level, but that would be extortion. Okay, money laundering. What is that?
Oh, that's a.
I often money launder. I will find bills in my jeans pocket, let's say, after I've washed my jeans and then dried them, and the money is crisp and clean. It's beautiful. That's money laundering, right?
That is one form, not what we're talking about
today. That's
today.
not criminal. Tell me what is criminal.
Oh, that's there's a number of different statutes, not just statewide, but federally, and it has a set of very specific requirements that I could probably go over in 10 minutes that we don't need to. But
we don't need to.
No, but I think the big takeaway is if something feels like money laundering, the way we use that colloquially, it may very well be a crime. It may be a type of theft that we talked about, or embezzlement, but it may not actually meet the precise legal standards of what is money laundering.
Now, I can't think of, because I don't understand what money laundering really is, other than the trope that we see on TV where, like in Breaking Bad, there was this trope, they bought the car wash so they could take all this cash that he was getting and have it came from this legitimate business. They have to have an explanation. To me, that's all I know about money laundering. How could money laundering colloquially, like you used it in extortion, like they're raising our rates and it's extortionary. How would somebody falsely use the term money laundering in an HOA sense and it's not money laundering?
Yeah, I think we have a number of cases where our clients are very concerned about where their money's going, right? They have dues and they don't know, if it's going toward different insurance policies, or maybe they have questions about how the HOA is spending their money. And something seems fishy, and maybe it's negligence, maybe there's something intentional going on, and so they'll use the term that like, oh, I think there's money laundering going on. They're taking my money and they're using it for something else, and really what they're describing again might be
breach of fiduciary duty or negligence or
a very valid civil claim, but probably not the criminal offense of money laundering.
Right. That's probably not even going to happen, right?
Right.
And then there's something, and we hear this all the time. Clients will say that their money is being misappropriated. They're misappropriating HOA funds. That sounds very criminal. Even I know it's not. Misappropriation of funds colloquially means they're misusing funds. That is certainly civil in nature. If that's true, it's breach of fiduciary duty, it's breach of contract, it's negligence, it's a lot of things. But is there even a crime called misappropriation of funds?
It comes up in the theft context, but
that's theft. Is there a crime called misappropriation?
It is listed under theft, but it's not what people think it is. If you are misappropriating funds by stealing it, then sure, but that's often not what our clients are talking about.
Right. They're talking about misusing. Yeah. They should say they're misusing funds, but they use the term misappropriation.
Right. It's not typically a crime to make bad decisions with people's funds. It's a crime to take it for your own use.
Exactly, which is what we started off by talking about some actual crimes and how they could manifest in real life, and among those was embezzlement. Right. Okay. Now there are crimes that are built on false documents. Okay. For example, boards that falsify records to justify actions. Right. Expose themselves to serious penalties, including criminal. Okay. So I know that filing a false document can be a crime. If you submit a forged, and again, we're talking about forgery here, right? But if you submit a forged, here's one I can think about. Tell me if this would be criminal. We talked in our 2-part reserve study episode, we talked about how some boards will intentionally change a reserve study prepared by a reserve study expert, okay, a reserve study company, in order to falsely prop up that percent funded number. And then that report gets shared, let's say. Is that a falsification, filing a false document, even though it's not filed?
So most of the criminal offenses have an element of that false document being submitted, right? Submitted to a government agency, a state agency, submitted
Got it. So
somewhere.
That wouldn't be a crime.
Yeah, lying to your neighbors typically is not a crime.
Okay, let me give you this scenario then. Let's assume for a minute, let's talk about the balcony law. So the balcony law required all the HOAs in California to have conducted and completed their investigations subject to the balcony law requirements. I won't go into those because we have a separate episode on that. But by the beginning of this last year, 2025, okay? And to the extent that there's a problem, like the report says we've got a problem with these balconies or whatever, you have to turn that into the city or to the local government, typically the municipality. Let's say that the HOA gets the report back from the engineer or whoever was hired, the licensed expert that was hired to do the balcony inspections of a particular HOA, and there were some dire warnings, there were some issues, and they went manipulated, changed that person's report, and then submitted that.
Yeah, now we're talking about a crime.
That's a crime.
Absolutely.
Okay, so it's the filing with a government agency is what made that one a crime, correct?
Yes, it wasn't just changing some paperwork and misleading the neighbors. It was representing to wherever they're turning it in that something was the case.
To a basically police power agency.
Yeah, and that's the type of, if that happened, that would be the type of fraud that would actually really get attention because you're putting lives at risk.
Especially. You weren't in. I don't know. You probably saw our balcony law episode,
right?
But you weren't guest hosting that. But we talked about the Berkeley incident that spurned it, or that started it. Okay, so I understand that distinction. Thank you. So that's the filing of a false document that you were talking about. Okay, now there are also other document-related crimes or document-related issues that would be crimes that aren't to a government. For example, correct me if I'm wrong, but if an HOA takes bank records and alters them and then distributes those to homeowners, that altering of bank records is still a crime, right?
Yeah, they're still altering one of the records that they're representing out to the homeowners as part of their, their financial stability or something.
Right, but then why wouldn't that apply to the reserve study that I said if they alter a reserve study and they hand it to the homeowners? Why is that not? And by the way, let's not diminish. These are all breaches of fiduciary duty, serious ones,
right?
And can constitute fraud in the case of the when we were talking about the reserve study. That's fraud too. But why wouldn't that be criminal? I thought the bank record one was criminal because under federal law, you can't alter bank records.
Yeah, going into it, I think a lot of it depends on what happens after the record's been altered, right? If you have a statement from your bank and you decide to, mess with it for whatever reason because you want to make it look like you have more money than you do, but you don't do anything with that record, that's not going to be a crime. It's the action you take.
Yeah. Okay. Yeah. Got it. Okay. All right. And then, of course, another one of these crimes built on false documents would be perjury. In an HOA context, perjury would absolutely rear its head in the context of, let's say, well, the easiest way I can think of is in the course of litigation of some sort, discovery. All responses to discovery, whether it's signing a deposition or it's written discovery, you're answering requests for admissions or interrogatories, those are signed under penalty of perjury. So technically speaking, if you lie under penalty of perjury, you could go to jail. That's a crime, right?
That is technically perjury. Yep.
So now they don't prosecute that unless there's a political reason for it. We saw that, we see it once every few decades, I guess. But
it's
technically
rare.
It's a crime.
It's very rare. It does happen, but it's rare.
Yeah, which is too bad because it really should. It should be because the whole system breaks down when people lie.
Yeah,
and we see that all the time. Okay, good enough. So now there are, the perjury is probably a misdemeanor. I don't know when it...
Felony, actually.
Is it really?
Yeah. Yep.
Oh, okay. That's a felony. Lying on your discovery is a felony.
In California.
Huh. Okay, well, I didn't know that. So there are... okay, so the one where you manipulate the balcony law or manipulate that guy's report, let's say, or that gal's report, the expert's report, that would be a felony too, right?
Yes, that would most likely be a felony.
Okay. And felonies are the bad ones. Okay. All right. Now there's this, when we were talking about doing this show and I wanted to have you on as our guest, you mentioned to me something I'd never heard of, something called Marcy's Law. And could you tell us what is Marcy's Law and how does it relate to a criminal conduct in the realm of an HOA?
Sure. So Marcy's Law, also called the Crime Victims Bill of Rights, is written into the California Constitution, and it lays out what rights you have as a victim regarding your case. And it's something that a lot of people don't know about, or they might have misunderstandings about the power that they have to be notified, to be involved. And it's something that we would deal with a lot in the DA's office, having victims that just didn't know how to get information, didn't know what they were entitled to know about, or when they could give input. And Marcy's Law kind of lays that all out.
Okay, so based on what you were telling me, Marcy's Law is that victim's Bill of Rights that it empowers them or gives them certain rights. For example, give me the top 3 or 4 of the rights with respect to what a victim can technically has a right to. Give me 3 or 4 of those.
Sure.
The biggest ones.
I'd say the biggest ones are being able to give input to the prosecutor about what you'd like to see happen with the case. And as we would always tell victims and their families when we met with them, we're not your attorney, you didn't hire us, you can't fire us, but we are going to take into consideration whatever you have to say. We want to know what you'd like to see happen with the case.
And to hear about maybe what impact the crime had on them, because you guys, before that, the DA, you guys would just get report from the police or whatever, just be files. And that doesn't communicate a whole bunch, does it? It doesn't communicate the impact on the families and the things that have happened. And this adds a little bit more, I guess, of the human element to it, right?
Absolutely. As a prosecutor, you're often making decisions, just reading reports and looking for the elements of a crime. Have they been proven? Is this the person who did it? And then trying to make a sentence recommendation without really having the full context of how it may have affected the people involved. And so under Marcy's Law, you have a right to let the prosecutor know before they resolve a case how this has impacted you, give them the context, and then if the case actually, so that can impact the filing decision, and often we would speak with victims or Marcy's law attorneys who are speaking on their behalf to understand the case before we made a final filing decision.
Give me a couple more, and then I want to go back to that Marcy's law attorneys. Is I know when we were talking about this, you told me something about that, so I have a question about that.
Yeah.
But give me two more rights that you get under Marcy's law.
Another big one is if the case gets filed and goes to court, you have a right to speak to the judge, you or your attorney, and before the judge either makes an offer or does something to the case. Sometimes it doesn't even have to be an offer. It could be regarding bail, regarding a protective order.
Oh, really?
You have the right to let the judge know, not just the prosecutor, how this has impacted you, and speak directly to the judge if you'd like.
Are you given all the dates of like the pre-hearings or what do you call them, preliminary hearings?
Yeah, that's probably the third of the big three is you have a right to know what the court dates are before anything major happens. You have the right to be at all the hearings if you want to, and a lot of people don't, and I totally understand that.
What if it's one of those media circus trials where you have people waiting at, like the Michael Jackson? I just remember there, hundreds of people trying to get in. You have the entire press trying to get in, and there's a limited amount of seating, right? So you'd have to get in line hours before. Do they reserve some seats for the victims or, presumably people under the Marcy's law thing?
The victim's never going to get shut out of the courtroom. You may not have a special line to get in, but once you make it to the courtroom, they're not going to keep you out there. You have a right to be there and to be present for all hearings.
Okay, fair enough. Good. Okay, now to my question. You had mentioned a Marcy's law attorney when we were talking about this topic, and I asked you what that was. Can you just give us a real quick rundown of what does that mean? What is that?
Sure. This is a growing practice because what a lot of people found was, some civilian reports a crime, the police come out, they take a report, and then the person has no idea how to find out what's going on with their case. And it can be a lot of work, or it can be intimidating to call up a police department and be like, hey, I want to talk to the detective, tell me what's going on, or to call up the DA's office and say, are you going to file this? And let me try to convince you to file it. So there's been a growing field of attorneys who take on this role and can coordinate that. They know who to talk to. They know how to get a hold of the right person to find out what the status is. And
who's in charge of it? Who's the DA?
Right. You're right. To find out those things so that they speak with the right person, and then to give input, and they can meet and give that input and do that on the victim's behalf, so they don't feel like they have to, like they're fighting alone. Right. Like it's all on them.
All right. I love that. Thank you. Okay. So Marcy's law, of course, it covers every victim, whether it's a corporate victim, a member of an HOA, or a victim of a violent, it doesn't matter. It all applies.
Every crime, from a murder down to the smallest misdemeanor.
Okay. Now, the next thing I want to talk about is this is different than the earlier topic we covered before when we were talking about terms that people use that they use it differently than they use it colloquially. And so they use it wrong, basically. They call something that sounds criminal but isn't. They use a criminal word to describe it, right?
Right.
Here, I want to talk about what's not criminal, even though it feels like it should be. So it's a little bit different, but it's a subtle difference, but it's important because these are HOA stuff, right? So, for example, in other words, many board actions feel very abusive, but they don't rise to the level of criminal conduct, even though they feel like they should, but they don't. And that's what I want to do here. So, for example, selective enforcement. I can't contemplate a way selective enforcement would ever be criminal. No, I can't think of a fact pattern where that would be criminal unless it was coupled with an actual crime. Like you selectively enforce against his family and you hit him with a baseball bat. That's criminal.
Right.
All right. But it's not the selective enforcement that's criminal. It was the baseball bat part. So selective enforcement seems very, in many ways, it can, especially if it's racially related, it could be very discriminatory, and you feel like it should be criminal, like a hate crime, but it's not, because that's not what a hate crime is.
Right. Yeah, I actually prosecuted hate crimes for a while, and one thing we would have to explain, because you get all sorts of reports and hear people have all sorts of horrible things happen to them, is explain the difference between a hate crime and a hate incident. And a lot of what might take place with an HOA is a hate incident. It's hateful and it's offensive.
And it might be actionable civilly.
Absolutely.
But not criminally.
Yes, you still need an underlying crime.
Here's one Now, conflicts of interest are purely civil, always have been, and you can sue for that. You can sue. It's a breach of fiduciary duty to continue to serve if there's a direct conflict of interest. For example, if a director is trying to foist a valuable contract onto his brother's contracting company, and give him a sweetheart deal, that's a conflict of interest. It's not a crime, though. Okay, but kickbacks. You were telling me kickbacks weren't even a crime. It's not enough for there to be a quid pro quo. Yeah, you give us a favorable this and I'll give you $100. So to use an example, I think we talked about this yesterday. You and I were talking yesterday, when we were talking about this episode, and I gave the example of, a board member saying, hey, give me $500 and I'll make this go away. I guess that was before AB 130. So now it'd be, give me $100 and I'll make sure you win your hearing, That's a kickback. That's a bribe, right? But it's not a crime.
Right. If we're getting into threats or harm or, making someone do something under duress, that's
different.
That's different.
Right. A kickback is a bribe.
Right.
But if you couple that with, give me the $100, I'll make this go away. But if you don't give me the $100, I'm going to break your legs. Now we got a crime.
Sure.
Yeah. Okay.
And there are, I should clarify, there are crimes related to public officials who engage in kickbacks. If you're an elected official, if you're in the government.
Yeah, but not in an HOA.
Not in an HOA setting.
That's what we're talking about. Okay. So basically, harassment and retaliation, both of which are highly actionable civilly in an HOA setting, would not be criminal unless they were coupled with a criminal threat of physical harm or harm to property. Right?
Right.
Okay. All right. That makes sense. Same with fiduciary duty, folks. Fiduciary duty. And I have an entire episode. You can find it. I think we published it last week. Entire episode dedicated to fiduciary duty and a couple articles on the website. Not a crime. Breach of fiduciary duty is, you can get punitive damages for that in certain cases, but it's not a crime. And then, of course, there's harassment and retaliation. Harassment and retaliation, absolutely actionable in HOA context in a civil level. It's illegal. It violates the Davis-Sterling Act. It violates the FHA and FEHA, which we've talked about in our harassment episode and in articles on my website. But it's not criminal. If your HOA is selectively enforcing against you because of your race or because of your gender or because of your sexual orientation, that violates a whole host of California and federal laws civilly, but it's not criminal unless, and correct me if I'm wrong, it's coupled with threat of violence or a threat to your property.
Yeah, you still need some underlying crime to go with the discrimination or harassment.
So let's transition briefly to penalties and real-world outcomes with respect to HOA-related crimes. Just like any crime, whether it's assault and battery or bank robbery or embezzlement of HOA funds, if you're convicted, you can go to jail.
Yes.
Right? You can be put on probation. You could be ordered to, if there's an actual victim and there's money, the person's out of pocket, you could be ordered to pay restitution, which is, I guess, similar to a compensatory judgment in a civil case.
Yes.
But there's also fines and statutory penalties, which, unlike a civil case, statutory penalties in a civil case are paid to the plaintiff also. Once in a while, it's owed to the court, but most of the time, if you get sanctions or you get penalties like under 5,200, if HOA doesn't give you documents, you can get $500 per request, right? That's all paid to the plaintiff. But in criminal, restitution's paid to the victims, but fines and penalties are paid to the court, correct?
Yes.
Right. And so that is a difference, but that applies to HOA crimes and non-HOA crimes, right?
Right.
So let's kind of wrap things up by talking about what to do if you believe a crime has occurred in your HOA. If you believe one or more directors is engaged in embezzlement, certainly I would report it. But before I would do that, we'll get to that second. I think the first thing is gather your evidence. Gather documents, gather video, gather pictures, gather anything that you can, text messages, emails, it doesn't matter, that tend to prove that crime occurred. The more you can give the DA, the better. I like to say I want to give that DA the case on a silver platter. That matters, right?
It does. Yeah, okay. Absolutely.
So we want to make their job as easy as possible because remember, DAs have a lot of discretion in whether to prosecute. And one of the things they're going to look at is do I have a reasonable chance of being able to convict on this, right?
Right.
So the more you can give them, the better. It doesn't mean they won't do their own investigation and find more stuff, but you at least want to bring them as much as you can get them, okay? Now, I would also report it. If I find out that embezzlement has occurred, I am going to report that. That's a big deal to me. People should be held accountable. So if I see a crime, I'm going to report it. Now, you said earlier, for example, Orange County DA's office has an insurance division, right? I assume they also have a white-collar crime division.
Yes, there's a major fraud, insurance fraud, a couple different areas.
Embezzlement is white-collar crime, whether it's HOA embezzlement or embezzlement in a bank, it doesn't matter. It's still white-collar crime. So I might try calling the DA. Now, the DA, you were telling me that the DA, every DA's office has their own kind of internal rules as to whether or not they will listen directly from the public to report the crime or they'll direct you to the police. But it doesn't hurt to try. Right?
Yeah, every county's set up different. Every DA's office has a different deal with their investigators, but especially for financial crimes, you know, if it's a robbery, you're not going to report straight to the DA's office. You're going to call the police. But a financial crime, you may want to just check and see if it's something they take directly or if they want you to go to your local police department.
If I can avoid the middleman, I'm going to avoid the middleman. But worst case scenario, they'll direct me to the police anyway.
Right.
And they might even give me a better number to call, to be honest, because you're not going to call 911 for that kind of crime.
Yeah.
Okay. So you want to report it. You want to gather your evidence. You want to marshal it, and you want to present it to whoever you're calling. And lastly, I think you want to call HOA counsel. You want to call our office at MBK Chapman. If there's a victim component beyond just like a financial, like let's say there is a threat or there was an assault and battery or something like that, I would also maybe, based on what you taught us about Marcy's Law, I might also call a Marcy's Law lawyer.
Yeah, if you're serious about bringing this into the criminal side, it's important to talk with someone who knows who to talk to, who knows where your case is going to go, who's going to look at it, and can provide that person with the context they need to make a decision. I
think that's perfect. Bottom line, folks, is this, and I hope that we helped you see this today. Most of the wrongdoing that occurs at HOAs, even really, really bad HOAs, it could be very illegal civilly, but it probably doesn't rise to the level of criminal. But we identified a few areas where it would be. Embezzlement being, I think, probably the most common in an HOA context, the most common sorts of wrongdoing that would also be criminal. But I have a feeling we're going to see more and more fraud in terms of the types of paperwork that's being manipulated and handed to city inspectors, after balcony inspections. I think we're going to see that. I've seen one of those already. And so I think we're going to see more of those as more and more HOAs become compliant with the law, because the results of not doing that could be catastrophic for an HOA that hasn't been maintaining and doesn't want to see all of their balconies red tagged when they don't even close to have the money to fix it. And so I think we're going to see more of that. But bottom line is, if you believe that you've got criminal activity in your HOA, then by all means do what you need to do. But I hope we kind of explained how to spot the real crimes from the things that seem like they're crimes but aren't. If you like this episode, please hit the like button. And if you haven't already done so, please subscribe to the channel HOA Hell. If you'd like to leave a question or a comment, we'd love to hear from you. And until next time, have a wonderful day.